we've got a major development in the fight to remove suppressors and short-barreled rifles from the NFA. And this one's getting interesting because the Trump DOJ just got caught trying to pull a fast one on the court. The Department of Justice filed yet another brief defending what's left of the NFA restrictions. But here's where it gets good. The plaintiffs just fired back with a motion accusing the DOJ of breaking court rules and sneaking in brand new evidence at the last possible minute to try and save their case. So let's break down exactly what just happened, why the Trump DOJ is now in hot water, and what this means for the future of NFA restrictions on suppressors and SBRs. If you've been following this channel, you already know that H.R. 1 passed through what they called the One Big Beautiful Bill. And buried in that legislation was a massive change to the NFA tax structure. The tax on items like suppressors, short-barreled rifles, and short-barreled shotguns dropped from $200 down to $0. That's right, a complete elimination of the transfer and making tax. Now, after that happened, several Second Amendment advocacy groups saw an opportunity. They decided to finish the job and push to eliminate the remaining restrictions, things like the transfer restrictions, the registration process, and all the bureaucratic red tape that comes with it. The strategy here is smart. They're trying to leverage that $0 tax to argue that the entire foundation of the NFA has collapsed. One of the major cases pushing this argument forward is the Silencer Shop Challenge against the ATF. Gun Owners of America, the Firearms Regulatory Accountability Coalition, also known as FRAC, Silencer Shop, Palmetto State Armory, and Silencer Central, all joined forces to file this lawsuit. And it's not just private companies and advocacy groups. Multiple states have also joined as plaintiffs in this case, which adds significant weight to the legal challenge. The core legal argument. The core argument in this case is actually pretty straightforward once you understand the constitutional framework. The plaintiffs are arguing that because these firearms are no longer taxed, Congress can no longer justify regulating them under their taxing powers. And this matters because the original constitutional basis for the NFA was Congress's power to tax. Therefore, they argue the NFA's registration and transfer requirements now exceed Congress's enumerated powers. In other words, Congress doesn't have the constitutional authority to keep these restrictions in place without the tax. Both sides in this case are trying to end it as quickly as possible through what's called cross motions for summary judgment. Essentially, they're both asking the judge to rule in their favor based on the legal briefs and arguments alone, without going through a full trial. This is significant because whoever wins at this stage could potentially set nationwide precedent affecting every gun owner in America who wants to own a suppressor, or SBR. The DOJ's original arguments. In their original brief, the Department of Justice made several key arguments to defend the remaining NFA restrictions. Let me break down their three main positions. First, the DOJ argues that even though the making and transfer tax is now $0, there's still a special occupational tax, the SOT, on manufacturers, dealers, and importers. They claim the registration system is part of what they call a web of regulation that helps enforce this remaining tax. Therefore, they say it still fits within Congress's taxing powers. Second, the DOJ argues that the NFA is independently valid under the Commerce Clause. Their position is that the NFA regulates firearms moving across state lines and through interstate commerce, which gives Congress the authority to regulate them regardless of the tax. They even go further and say that purely intrastate activity, like making a suppressor in your own home or manufacturing them exclusively within a single state like Texas has tried to do, can still be federally regulated. Why? Because they claim unregulated submarkets would create a gaping hole in the federal regulatory scheme. Third, and this is where it gets really interesting, the DOJ argues that even if the court finds constitutional problems with their taxing power and Commerce Clause arguments, the NFA still doesn't violate the Second Amendment. Yes, you heard that right. The Trump DOJ is actively arguing that the NFA does not violate the Second Amendment. They're relying on older court precedents claiming that these types of weapons fall outside the core protections of the Second Amendment. The new development, DOJ gets caught. Now here's where things take a turn and where the Trump DOJ gets caught doing something they shouldn't have done. After the plaintiffs filed their response to the DOJ's arguments, the Department of Justice filed what's called a reply brief. And attached to that reply brief was a brand new declaration from the ATF that had never been submitted before. This new declaration tries to claim that the NFA's registration system is still necessary because the ATF supposedly denies hundreds of applications each year, due to special occupational tax issues. But the plaintiffs immediately caught a huge procedural problem with what the DOJ just did, and they're not letting it slide. The plaintiffs are pointing out that under the court rules in the Northern District of Texas, where this case is being heard, you are not allowed to introduce new evidence at the reply stage without getting express permission from the judge first, and the DOJ never got that permission. Instead, they tried to slip this new piece of evidence into their reply brief, hoping it would just slide through. So now the plaintiffs have filed a motion asking the court to do one of two things: either strike that new evidence entirely and throw it out, or at the very least give the plaintiffs the opportunity to respond to what the Trump DOJ just submitted. The plaintiffs argue, and I think this is a strong point, that the DOJ already had months to submit evidence supporting their legal arguments. In fact, the Trump DOJ already filed one affidavit earlier in the case. This new declaration is essentially a second attempt to patch up the weaknesses in their case after they saw how strong the plaintiffs' arguments were. In legal terms, this is called taking a second bite at the apple. The DOJ realized their original arguments were weak, saw what the plaintiffs filed, and then tried to shore up their position with new evidence that they should have submitted months ago, attacking the substance of the new evidence. But the plaintiffs didn't just attack the procedural violation. They also went after the substance of what the DOJ is claiming in this new evidence. The DOJ's new declaration claims that in 2025, the ATF denied about 691 applications due to special occupational tax issues. At first glance, that might sound like a lot, but here's the context the DOJ conveniently left out. The ATF processed more than 2.1 million NFA transfers in that same year. Let's do the math. 691 denials out of 2.1 million applications equals about 0.03%. That's 0.03%. And here's the kicker. This actually supports the plaintiff's argument, not the government's. The plaintiffs have been arguing all along that the registration system is not meaningfully connected to tax collection, and these numbers prove exactly that. If you're only denying 0.03% of applications for tax-related reasons, how can you seriously argue that this massive registration bureaucracy is necessary to enforce the tax? The plaintiffs also point out another problem with the DOJ's new declaration. It relies heavily on past practices under the old law when there was still a $200 tax in place. But we're living under a completely different system now with a $0 tax. The declaration doesn't explain why those same procedures make sense going forward under the new tax structure. They're relying on old evidence from an old system, but presenting no compelling arguments for why any of this is still relevant under the current $0 tax framework. In short, even the DOJ's new evidence doesn't fix their constitutional problems. It might actually make them worse. Where this leaves the case. So where does all of this leave us in this critical challenge to the NFA? Let me paint the complete picture of where we stand right now. The current reality on the ground. We now have a $0 tax on suppressors, short-barreled rifles, and short-barreled shotguns. This isn't theoretical anymore. Since this change took effect, thousands of gun owners across the country have already gone through the new system. They've filled out the forms, submitted their fingerprints, waited for approval, and received their tax stamps, all without paying a single dollar in transfer or making taxes. But here's what they quickly realized. Even though the tax is gone, everything else remains. The registration requirements, still there. The waiting period, still there. The transfer restrictions, still there. The mountains of paperwork and federal oversight, all still there. And that's exactly what this lawsuit is challenging. The legal battle taking shape. A coalition of major Second Amendment organizations and multiple state governments have joined forces in what is now one of the most significant NFA challenges in decades. They're not asking the court to tweak the system or make minor adjustments. They're asking the court to dismantle the remaining NFA restrictions entirely. On the other side, you have the Department of Justice under the Trump administration, led by Attorney General Pam Bondi, working hand-in-hand with the ATF to defend every single restriction that remains. And let me be clear about this. They are fighting aggressively to preserve the status quo. The procedural battle within the battle. But now, we've got a second fight happening within this larger case, and this one's about process and fairness. There's a procedural dispute brewing over whether the Trump DOJ even followed the court's own rules when they submitted that new ATF declaration in their reply brief. Think about what happened here. The DOJ filed their initial brief with their arguments and evidence. The plaintiffs responded and pointed out the weaknesses. Then, instead of accepting that their case had holes, the DOJ tried to patch those holes by introducing brand new evidence at the reply stage, a stage where new evidence typically isn't allowed without permission. They didn't ask the judge for permission, they just did it. What the judge must decide. The judge now faces a critical threshold decision before even getting to the constitutional questions. Does the court strike this new evidence and throw it out completely as procedurally improper? Or does the court at least give the plaintiffs fairness and allow them to file another round of briefing to respond to evidence they never had a chance to address? This might seem like a minor procedural issue, but it's not. If the court allows this evidence to stand without giving the plaintiffs a chance to respond, it sets a dangerous precedent that the government can introduce new evidence whenever it wants, even when the rules say otherwise. The bigger constitutional questions. But let's zoom out for a moment, because this case is about something much larger than courtroom procedure. This case is fundamentally about the limits of federal power and whether Congress can continue to regulate something once its stated constitutional justification disappears. The original justification for the ENFA was Congress's power to tax. That's what the Supreme Court relied on in the 1930s when the NFA was challenged. But now that justification is gone, the tax is zero. So the question becomes, can Congress continue to impose all of these registration requirements, transfer restrictions, and regulatory burdens when the constitutional foundation they were built on has been removed? This gets to the heart of enumerated powers in federalism. Congress doesn't have unlimited authority. They can only do what the Constitution allows them to do. And if the taxing power was the constitutional hook, and that hook is now gone, what's left? The DOJ is scrambling to find new constitutional hooks, arguing the Commerce Clause, arguing necessity, arguing public safety. But the plaintiffs are pushing back hard, saying you can't just swap out constitutional justifications when the original one disappears. That's not how enumerated powers work. The double standard problem. Here's what really matters about the procedural fight. It exposes a larger problem in how federal litigation works. The plaintiffs in this case, these are private advocacy groups, private companies, and state governments. They have to follow every single court rule to the letter. If they miss a deadline by one day, their filing gets rejected. If they try to introduce new evidence at the wrong stage, it gets struck. The rules are rigid and they're enforced strictly. But the federal government, they often get treated differently. Courts give them extensions. Courts overlook procedural errors. Courts give them the benefit of the doubt. In this case, the plaintiffs are saying, enough. If we have to play by the rules, so does the Department of Justice. If we can't introduce new evidence at the reply stage, neither can they. Equal treatment under the law should mean equal treatment in the courtroom. And the fact that the plaintiffs caught this and are calling it out publicly shows they're not just fighting the substantive legal battle, they're also fighting to ensure the process itself is fair. What this means, going forward. So right now, we're in a holding pattern, waiting for the judge to rule on this procedural motion. But make no mistake, the resolution of this procedural issue could significantly impact how the rest of the case unfolds. If the court strikes the DOJ's new evidence, their case gets weaker. If the court allows it but gives the plaintiffs a chance to respond, we're looking at another round of briefing, which delays the final ruling but ensures fairness. And if the court just allows the evidence without giving the plaintiffs a response opportunity, that would be a major win for the government, and a concerning signal about how the rest of the case might go. Beyond this immediate procedural fight, the bigger constitutional questions are still looming. Can the NFA survive without the tax? Does the Commerce Clause really give Congress this much power? Does any of this violate the Second Amendment? These questions have nationwide implications. We're not talking about a single state or a single regulation. We're talking about federal restrictions that affect every American who wants to own a suppressor or short-barreled rifle. Millions of potential gun owners are watching this case because the outcome will determine whether they'll ever be able to exercise their Second Amendment rights without federal registration and bureaucratic hurdles. So that's where we stand right now in this critical nationwide NFA challenge. The DOJ continues fighting to preserve what's left of the NFA. The plaintiffs continue pushing back with strong constitutional arguments, and now with procedural challenges to the government's tactics. And the court must decide how to handle this new evidence issue before moving forward with the bigger constitutional questions. This is a developing case with nationwide implications. As we get more information and as new developments unfold, I'll keep you updated right here on this channel. If you found this breakdown helpful and you want to support the channel, one of the best ways to do that is simple. Hit that like button, drop a comment below with your thoughts, and subscribe if you haven't already. All of those actions help fuel the algorithm and tell YouTube that you appreciate this type of Second Amendment content, which means it'll get shared with more people who need to see it. But as always, thank you so much for all of your support.